Hello, good morning, good afternoon, good evening, everyone. I'm Heng Wang, co-director of the Herbert Smith Freehills China International Business and Economic Law Center at UNSW Law Justice, and co-director of the Tsinghua UNSW Joint Research Center for International Commercial and Economic Law. I'm delighted to welcome you all to this 2022 JCICEL conference, the Tsinghua UNSW Joint Research Center for International Commercial and Economic Law. I begin today by acknowledging the traditional custodians of the lands on which we meet today, the Badago and Gadigal people, for where UNSW stands, and pay my respects to the elders past and present. I would also to extend that respect to other Aboriginal and Torres Strait Islanders who are present today. Before we start, I would like to extend the sincere thanks to the Tsinghua Law School colleagues for participating in the conference. And also, please let me introduce a little bit about the conference. The Tsinghua UNSW Joint Research Center for International Commercial and Economic Law, JCICEL, was established in 2019 between UNSW Law Justice and China's Tsinghua University Law School. It aims to develop a group of world-leading researchers in international commercial and economic law on general legal issues and China-specific issues. We will have two sessions today, and this session, including open remarks by the deans of two law schools and law faculties, as well as a second session at 4 p.m. sitting time today that will cover recent developments in competition and digital regulation. And also, without further ado, I would like to introduce Professor Andrew Lynch, Dean at the UNSW Law Justice, to give the opening remarks. Let's welcome Professor Andrew Lynch. Thank you.
Thanks so very much, Heng. Good afternoon and good morning and good evening to everybody, no matter where you are joining us from. I am Andrew Lynch and the Dean of the Faculty of Law and Justice at the University of New South Wales in Sydney. And it's my great pleasure to welcome all participants and guests to the annual Tsinghua UNSW Joint Research Center for International Commercial and Economic Law, or JCICEL, conference. UNSW Law and Justice has a well-established and enduring relationship with the Tsinghua Law School. The Herbert Smith Freehills Siebel Centre has facilitated this connection through various event collaborations, which include the 2018 Tsinghua UNSW keynote held in Beijing, the Siebel Roadshow, and of course, these inaugural JCICEL events. I would like to extend my thanks to all Tsinghua members who have helped us create and advance this important initiative. JCICEL is a joint centre established by two of the world's leading law schools. Its research focuses on areas from competition to trade and investment, and will often address recent developments and emerging issues within these dynamic fields of law. This collaboration supports world-leading research through a global partnership, which helps us both achieve our strategic goals. This year, the conference continues to focus on cutting-edge issues within international commercial and economic law from two major perspectives. Panel 1 looks at the issues in practice within trade and investment law, including security, force majeure in investment arbitration, RCEP, and anti-monopoly enforcement. Panel 2 investigates the developments in competition and digital regulation by looking at the recent amendments in digital regulation law, the issues within competition impact assessment, data protection, and insolvency law. This year's speakers contributing on these important topics include established scholars from both institutions with rich practical experience across varying fields of law, and a few of our recent PhD graduates, of whom we're immensely proud. We hope that JCICEL will offer our young scholars opportunities for personal and professional growth and support their career development. I want to thank all the experts who are joining us today for this event, UNSW Law and Justice looks forward to continuing to work with Tsinghua University Law School, their colleagues and emerging young scholars. And it's now my great pleasure to introduce Associate Professor Yun Long, who is the Associate Dean of International Affairs at the Tsinghua University Law School, to give us his remarks. Thank you.
尊敬的各位与会嘉宾，清华大学、西南威尔士大学国际商法和国际经济法联合研究中心的各位同事们，大家好，我是清华大学法学院的龙俊，非常荣幸能够代表清华大学法学院致辞。清华大学和西南威尔士大学于2019年联合成立了本研究中心，旨在共同推进在国际经济法和国际商法领域的学术研究，共同培养高水平国际商法和国际经济法人才。这些年里，我们就技术监管法律问题、国际商法与经济法的走势等议题展开了深入的学术探讨，取得了巨大的影响力。感谢西南威尔士大学和清华大学各位亲爱的同事们。我个人是研究民法的，也全程参与了中华人民共和国民法典的起草工作。就我个人的感受来看，民法典中越与商事有关的制度，在制度设计上就越与国际发展趋势相一致，典型的如债权让与规则、动产担保规则等等。也就是说，在商法和经济法领域，衡量一个制度设计科学与否的标尺正在趋同化，甚至能够跨越文化差异或者政治制度差异。我想，这是因为在经济全球化的今天，各国在经济发展中都遭遇了类似的问题或者挑战。可见商法和经济法领域的国际化研究具有巨大的前景。今年6月，中华人民共和国反垄断法被修订，8月实施。目前，中华人民共和国公司法也在修订过程当中，预计明年会通过。这些年，中国在民商法以及经济法方面的立法有了重大发展，这为我们的论坛提供了诸多素材。特别值得一提的是，我在清华的同事们也都深入参与了这些法律的修订工作，一会儿即将展开相关学术报告。我期待着就这些议题展开深入的学术探讨，探索出跨越国界的共通的发展道路。最后，祝本次会议圆满成功，谢谢大家。
Thank you very much, Professor Andrew Lynch and Associate Professor Jun Long, and very much for the great and warm welcome to all the participants to our event. Now, I would like to introduce Professor Guobin Cui of Tsinghua Law School as the moderator of Panel 1. Professor Cui has played a crucial role in the development of JCICEL and is an old friend of UNSW. And he is the director of the Center for Intellectual Property at Tsinghua Law School and was the associate dean for international affairs and academics. His scholarly interests include intellectual property, antitrust, property, and law economics theory. He has taught in intellectual property law, patent law, IP licensing, and Chinese civil law. Professor Cui has published over 20 law review articles and 2 popular case books. Before joining Tsinghua Law, he had practiced intellectual property litigation and licensing law in Beijing and Shanghai. And in 2008, he worked as an intern for Judge Rada at the U.S. Court of Appeals for the Federal Circuit. He was also a visiting scholar at, George Washington University, University of Chicago, University of Washington, as well as UNSW. He also serves as a adjunct researcher at the Center for Judicial Protection of Intellectual Property, the Supreme People's Court of China, and being a legal advisor to and also special juror at different courts, as well as legal advisor for People's Court of Haidian District of Beijing. Without further ado, I would like to hand over to Professor Cui Guobin, the chair of our first session. Thank you.
Okay, thank you, Professor Wang, for your kind introduction. I'm very happy to see Dean Lynch, Professor Wang, Professor Zhou, and Dr. Lu Wang, and other old friends from UNSW here. online. I'm very happy to participate in today's events organized by the Joint Center. I really hope the borders will be open again at the end of this year or at the beginning of next year, and so we could attend similar joint events in person in the future in Tsinghua or in UNSW very soon. Today, for this first panel on trade and investment, we have 3 speakers. They are Dr. Lu, Professor Zhou Weihuan, and Dr. Wu Peicheng. Our first speaker is Dr. Lu. Dr. Lu is a lecturer at the UNSW Law and Justice and a member of Civil Center. Her primary area of research interest is international and comparative economic law, with a particular focus on international investment law, international arbitration, state-owned enterprises, and Chinese regulation of foreign trade and investment. Before joining UNSW Law and Justice, Dr. Wang worked as a legal intern at the International Center for Settlement of Investment Disputes of the World Bank Group, and also intern at the Department of Treaty and Law of MOFCOM, Chinese Government Office. He was also a visiting fellow at the Luther Parker Center for International Law at the University of Cambridge. Currently, Lu serves as an affiliate expert of the Asia Pacific FDI network and works closely with international organizations and key actors involved in the field of foreign direct investment. Dr. Lu holds 2 PhD from the University of Liverpool of UK and the Xi'an Jiaotong University in China. Dr. Wang's topic for today's event is force majeure in investment arbitration between treaty and contract claim. Okay, now please join us to welcome Dr. Wang to give his speech. Okay, I'll give the podium to Dr. Wang.
Thanks, Professor Cui, for your very generous introduction. It's always a great pleasure to participate in the JCICEL annual conference, and I'm immensely grateful for having this opportunity to share one of my recent research and speak together with Weihuan and Matthew on developments in trade and investment more broadly. Today, I will talk about a co-authored paper on first mover and investment arbitration, recently published in a special focus issue of the JCICEL Review. The objective is to explore the intersection of the NLC's articles on the responsibility of states for internationally wrongful acts and investor-state dispute settlements, focusing on a narrow issue of first mover. We know that first mover is widely accepted in both domestic and international law, but it has hardly been referred to investment arbitration in the past. However, the ongoing COVID-19 pandemic and the Russia-Ukraine conflict may prove a turning point. We've already seen first mover being invoked in relation to the pandemic-related restrictions and supply reduction of gas and oil. So we believe that first mover is likely to gain wider use in investment arbitration in the years to come. And we are delighted to have this opportunity to address the interaction between first mover and investment arbitration, which is critical and challenging in a time of crisis as now. Next slide, please. So I'd like to talk briefly about the concept of first mover in domestic and international law, and to present an examination of first mover being invoked in different types of claims in investment arbitration to address the application of first mover and interpretation of investment obligations. Finally, I will share some thoughts on the implications and future of ISDS jurisprudence on first mover. Next slide, please. So first mover is a classic excuse for non-performance of obligation, and it is accepted by most legal systems and constitutes a general principle of law. The the actual term is derived from the French law, and force majeure is generally acceptable applicable doctrine in the civil law jurisdictions. By contrast, force majeure has no inherent meaning under English law, and it's mostly a contractual right in common law traditions. I'm not going to speak too much about the concept in domestic laws, but it's clear that there are differences in relation to force majeure between common law and civil law systems, and also among civil law jurisdictions. At the international law level, the CSJ provision presents a bridge between civil and common law systems by adopting a broad and flexible approach to cover force majeure. And apart from the international commercial laws, force majeure is also widely accepted in public international law. And the landmark is perhaps the codification in the ILC's articles on state responsibility. Can we move to the next slide, please? The definition of force majeure under RCEVA is considered narrow and strict. It is provided as one of the 6 circumstances precluding wrongfulness, requiring 3 constitutive elements, namely unpredictability or irresistibility of triggering events beyond the state's control, and material impossibility of performance. And the provisions also explicitly exclude the application if the state has induced the situation or accepted the risk of force majeure. Next slide, please. In the context of investment arbitration, force majeure has been invoked in both treaty and contract claims. So in treaty claims, ICS tribunals have recognized RCEVA conditions of force majeure, but have not engaged in detailed discussions on this issue. Although the case law is limited, it's clear that the ICS tribunals have applied a strict approach in treaty-based arbitration, following the requirements of ILC's articles on state responsibility. We considered that the limited usage of force majeure in treaty-based arbitration may be due to many reasons. On the one hand, the RCEVA set high thresholds for satisfying force majeure. On the other hand, force majeure is not the only available defense or technique to states to avoid responsibility under the investment treaty regime. We can see that states can rely on other customary law defenses such as necessity or the exception clauses included in investment treaties. Next slide, please. So, move to the next slide, please. So a survey on the investment treaties show that most investment treaties do not contain detailed rules on force majeure. And the most commonly found reference is the inclusion of force majeure circumstances in the so-called war losses clauses. Since the investment law rules are limited and narrow, it's not surprising that SDS tribunals have relied on RCEVA in the interpretation of investment obligations and circumstances precluding wrongfulness of states. Next slide, please. Apart from being an exception to state responsibility, force majeure has been invoked as an excuse for non-performance of contractual obligations in investment arbitration, especially in contract-based cases. In the contract claims, force majeure has been invoked by both foreign investors and host states. So here are 2 examples. In the Vista case, the respondent state invoked force majeure to excuse its failure to increase the toll rate under the concession due to civil arrest, but the tribunal was not convinced that the possibility of civil arrest could not be foreseen on the evidence. And the case is important because in that case, the tribunal also confirmed that force majeure was a valid excuse for non-performance of contractual obligations under both national and international law and consider that there should be no different standards between the two systems. But the interpretation itself is problematic as the Venezuelan administrative law does not require first mover to be irresistible and materially impossible, while these requirements are needed under RCEA provisions. In the RSM case, it was investor that invoked the first mover clause to justify its non-performance of contractual obligations. The tribunal confirmed that the alleged security situation was covered by the contractual definition and held that the conflict situation in the host state was unforeseeable. Next slide, please. So in contract claims, first mover is subject to the contractual provisions and the law applicable to the contract, including both national and international law. And the wording of first mover clause is crucial for the tribunal to determine the conditions and scope of first mover. Here are two examples demonstrating the importance of the wording, where the parties may exclude certain events from the definition. Next slide, please. A challenging issue in investment arbitration is that the SDS tribunals at times have to deal with interactions between contract and treaty claims. This may be called mixed claims, and this would happen particularly when the applicable investment treaty includes umbrella clause. In the mixed claims, there might be a conflict of standards for first mover and the issue of parallel proceedings as shown in this slide. Can we move to the next one, please? So what can we learn from the ICS jurisprudence of first mover and what are the implications for the future? We noted construct and interaction between treaty and contract claims involving first mover. The case law shows that the conditions of first mover applied in contract claims are broader and more flexible than that applied in treaty claims. And in our paper, we consider that the most fundamental rationale for such a difference might be the different role of the host state presumed in distinct claims. So in treaty claims, the role of the host state is presumed as public international law subject exercising sovereign authority. It is resourceful and powerful compared to foreign investors. So it's reasonable to adopt a narrow and strict approach to first mover for precluding wrongfulness of the state. The contrast in contractual claims, the host state is normally presumed as acting primarily in their commercial capacity and is supposed to be equal footing with foreign investors. We argue in our paper that the different standards applied by treaty and contract arbitration are rooted in the distinct systems of the applicable law. Traditionally, the two sets of laws operate in distinct spheres that do not cause many problems, but due to the mixed nature of investor state disputes, the boundaries between domestic and international private and public laws have increased blurred, and the legitimacy and sustainability of the conventional distinctions demand reconsideration. And according to the ICSID Convention, the ICS tribunal may have to apply both public international law and domestic private and public laws at the same time. And the umbrella clauses may make the issue more complicated in practice. So for the future, we suggest to explore a more consistent interpretation and application of first mover claims under the two legal systems. And perhaps one way forward is to allow more flexibilities in the interpretation and application of RCEA so that the international rule of first mover might be better aligned with first mover under the commercial law. All right, I shall stop here and thank you very much. I'm happy to discuss any questions further in the Q&A.
Okay, thank you, Dr. Wang, for your very interesting introduction to a very important issue. I think due to time constraint, probably you don't have time to expand details, but we have a Q&A session. I guess we will have more time to discuss the key issues involved in our paper. Okay, thank you. And now we go to the second presentation from Associate Professor Zhou Weihuan. Dr. Zhou Weihuan is Associate Professor and Director of Research at the Faculty of Law and Justice, UNSW. He published in the field of international economic law, particularly the nexus between international trade law and China. Personally, I read quite a lot of articles published by Professor Zhou on these kind of topics. His work has appeared in all top journals in the field and in some of the best journals in the broader field of international law. His publications are cited widely, including the European Parliament briefings and reports of the Parliament of Australia and Australia's Productivity Commission. Currently, he's a co-secretary of the Society of International Economic Law. Prior to UNS Law, he was a trade and a commercial lawyer and legal consultant at WTO. Weihuan's topic today is trade versus security, new developments in global trade rules and China's approaches. I think it's a very interesting topic. Okay, now please join us. Welcome, Professor Zhou.
Thanks, Guobin, for the kind introduction and very well generous introduction to my publications, and thanks for your interests. And likewise, we read lots of your publications and opinions on some of the most important issues in commercial law today. So let me just start by also jointly share my gratitude to the center, the joint center between UNSW Law Justice and Tsinghua University Law School, in terms of the great opportunities that the center has brought to us to collaborate with our dear colleagues at Tsinghua Law School, and also the opportunities for us to work together on some of the most important and current legal issues that has an impact regionally and globally. I think this joint conference today is another important event which seeks to address growing challenges in international economic law, competition law, and digital regulation. Now, the perspective from which I try to contribute to this debate about the ongoing trend in international economic law is the challenges posed by increasing invocation of national security or security concerns to justify unilateral measures or unilateralism and deviation from established global trade rules and from the rules-based multilateral trading system more generally. Now, my focus is on sharing observations and offering some explanations on how China has positioned itself in these contexts and has sought to address the various challenges faced by it. The tension between trade and security is no longer a new development. Although it started to intensify fairly recently, the United States' imposition of tariffs on steel and aluminum imports in early 2018 was perhaps a major catalyst provoking academic and policy debates over the nexus between trade and security in recent times. And yet, as widely known, it was just the start. These tariffs were followed by a series of heavier tariffs and other actions against China, dragging the two world superpowers into a 2-year-long trade war. It was also evident that security concerns have been one of the major drivers behind these actions, and these concerns are likely to continue to influence trade policy going forward. Now, before I explain China's engagement in and response to this trade and security challenge, let me put forward 2 general observations to set out the broader context. First, one fundamental issue here is not unfamiliar, I think, especially to those of us working in the field of international trade governance or international economic law more generally, which is how to strike a balance between preserving the policy space for governments to pursue security interests and preventing the abuse of security measures for protectionism and similar economic goals that unduly restrict trade, and frankly, to investment as well. This issue is not fundamentally different from the other issues which we also require a balancing act, such as trade and climate change, trade and environment, trade and food security. Just some examples that we heard often today. Those issues have come to the fore of academic and policy debates during COVID-19 pandemic. So therefore, one of the arguments that we often heard is that we need collective efforts of governments to resolve these global issues. Given the current WTO rulebook, there is only so much that the WTO tribunals can do, which I will come back to explain a little bit later. This obviously is a major issue emerged from the WTO rulings on security exceptions in two recent disputes, one between Russia and Ukraine, and the other between Saudi Arabia and Qatar. Well, the second point I want to make, the broader point I want to make, is the use and abuse of security-based trade measures or similar unilateral actions has been on the rise in major economies. It is no longer a problem with any specific country. China has been a major target and is likely to remain such a target as the US and its allies continue to treat China as a problematic competitor. These actions have triggered and will continue to provoke responsible actions from China. The result has been major economies increasingly taking the law into their own hands, which will be one of the major threats to the rules-based system and international cooperation, despite what has been achieved at the WTO's 12th Ministerial Conference. Now, it is within this broader context in which we discuss China's policy and regulatory approaches in response to foreign security-based or similar unilateral actions. In general, we see a clear shift of China's strategies from being defensive to an increasingly proactive one. China's strategy can be seen by considering how China has reacted at domestic and international levels. Now, I do not really have sufficient time to expand on these elements. I'll just give you some typical examples of how China has reacted at international and domestic levels. And then if you're interested in knowing the detailed analysis, we have published the paper in World Trade Review recently. And if you're interested, you can have a look into the paper. Now, at the international level, China started by taking a defensive position. I'll give you a couple of examples. The first is a largely defensive approach in response to proposals of WTO reforms. China concerned about abuse of national security by other countries, especially the United States, and proposed three actions at the multilateral level. The first is to strengthen notification requirements on security measures. Second, enhance multilateral reviews of security measures. And finally, provide flexibility for other members to take retaliatory actions. So as we can see, it's quite a defensive approach, which is basically adopted in response to US use of security measures. Another defensive approach taken by China was the retaliatory tariff against US trade war tariffs, and largely at the levels equivalent to or less than the scale of the US tariffs. Finally, the phase one deal between US and China to temporarily end the trade war, in which China undertook one-sided obligations, again, looking like a defensive approach. Now, more proactive approach has been taken in the WTO's dispute settlement system in China. First, China joins Russia, the Russia and Ukraine and Saudi Arabia disputes on security interests to try to promote its position on security exceptions or application of security exceptions. So that can be seen as a proactive approach. Second, China brought a series of WTO disputes to challenge the US tariffs, including the steel and aluminum tariffs and three on Section 301 tariffs, which involving US claims actions against China's intellectual property rights infringement. So, just very briefly, that's at the international level, at WTO level. And then at the regional and bilateral level, we have seen past publications talking about China's attitude towards the CPTPP, and starting from a defensive approach by criticizing the US policy as a containment of China, moving forward to take a more proactive approach in terms of promoting its own regional free trade agreement strategy in terms of the successful conclusion of RCEP. And later on, more recently, I think China's proactive approach was to request to join the CPTPP in the absence of the US. So that's another example of a proactive approach. The Belt and Road Initiative, obviously, without saying that it's one of the most important proactive approach China taken, not only have a trade investment and financial elements, but also always have embedded economic security and political security and strategic reasons. Finally, is China's recent use of economic power, which has been criticized in many ways in addressing disagreements on security-related issues in bilateral relations. So I think, in short, at the international level, we can see a clear shift of China's approach to security-related matters from defensive to increasingly proactive. Domestic level, now I see I have only 2 minutes left, so I'll be very quick. And also giving the audience here, I think there is no need for me to explain in detail about what China has been doing recently. But in my view, I think China started by revising or strengthening the security regulatory system, especially starting with the national security law in 2015, to expand the security interests and also to provide all sorts of flexibilities for China to take retaliatory measures to protect its security interests. And then during the US-China trade war, China has taken defensive approach, including to create its own unreliable entity lists, moving away from that to a more proactive approach by enacting a series of laws and regulations, including the export control law, China's anti-foreign sanctions law, etc. So how to understand the regulatory developments in China? We think that these developments have shown China's deep concerns about the uncertainties and anti-China actions in the global trading system, and its strong desire to develop sufficient regulatory tools to discourage these actions and protect its own development interests. Now, the question now is, like the US trade war tariffs, China security-based measures would generate the same criticisms about abuse of trade instruments in the guise of national security and continue to test the boundary of WTO's security exceptions. The more systemic issue concerns the major economies taking the law into their own hands on security or similar grounds. And therefore, for the WTO to stabilize and strengthen its role as the backbone of the multilateral trading system, it will have to find a way to discourage the use of such unilateral actions without its authorization. This requires collective action by all governments involved. I'll stop there and looking forward to discussions in the Q&A. Guobin, back to you.
Thank you, Professor Zhou, for your very interesting presentation. I actually have a question for you later on. I can look forward to more discussion on this. Okay, now our final speaker today is Dr. Matthew Peicheng Wu. Matthew is a research fellow at the Zhejiang University Guanghua Law School. His research focus on competition law, IP law, and digital law governance. He has published a range of articles regarding these fields in both English and Chinese. Matthew joined the Guanghua Law School of Zhejiang University this year after he's completing 2 PhDs, one from UNSW and another from Shanghai Jiao Tong University. Matthew is also a part-time research fellow at the Center for Competition Law and Policy of Shanghai Jiao Tong University. Matthew was a visiting researcher at the Chicago Kent College of Law in 2014 and research fellow at the University of Warsaw in 2019. In 2018, he was an intern judge assistant at the IP Division of Chinese Supreme Court. Matthew's topic for today's event is the implications of RCEP on anti-monopoly enforcement and dominant e-commerce platforms in China. They're a very hard issue now in China. Okay, look forward to your presentation, please.
Thank you, Professor Cui. I'm really honored to be introduced by you. And good morning, everyone. Good afternoon to my UNSW colleagues. I'm Matthew from Zhejiang University, Guanghua Law School, and also a recent PhD graduate of UNSW CIVIL. Today, I would like to share my topic, implication of the RCEP on anti-monopoly enforcement on dominant e-commerce platforms in China. The paper has been published on Computer Law and Security Review. And let's move on to the next slide. My presentation today is divided into 4 parts: the background, the anti-monopoly enforcement before 2020 in China, and the RCEP specific requirements, the current competition deficiencies in China, and also some potential RCEP implications on the anti-monopoly enforcement in China. Next slide, please. The first slide, the background, is very important. China has experienced a rapid development of digital economy since the 21st century, with many high-tech platforms established, such as Alibaba, Tencent, and Meituan. At the same time, the Communist Party of China has recently held the 20th National Congress, the report of which indicating that the government is going to build a digital China. After rounds of negotiations, Asia-Pacific countries, including China and also Australia, finally achieved the RCEP at the end of 2020. The most important goal of the RCEP is to establish a common and free market in the region. Besides the regional common market plan, China is also intended to establish its domestic national single market. Well, let's move on to the next slide. Well, 2020 is a watershed year of China's anti-monopoly enforcement. Before 2020, dominant e-commerce platforms in China raised many anti-competitive concerns among both online consumers and other online competitors. For example, Jingdong.com kept reporting Alibaba's 1 out of 2 practice, which may potentially violate China's anti-monopoly law. There are 3 main laws in China that may address digital antitrust concerns. The anti-monopoly law regulates the abuse of market dominance, which can also apply in digital sectors. Article 22 of the e-commerce law follows the anti-monopoly law, which further regulates the abuse of market dominance by e-commerce platforms. Besides, Article 35 of the e-commerce law regulates the superior bargaining position. Well, however, before 2020, China's competition agency rarely investigated e-commerce platforms, although there are still some civil antitrust cases between online platforms. Next slide, please. Well, the RCEP is regarded as a game changer for trade in Asia-Pacific region and provides some key requirements for e-commerce and competition. For example, in this RCEP agreement, online consumer protection is highly valued. It also requires member states to protect online personal information. The RCEP promotes cross-border e-commerce among member states and it requires reducing entry barriers. The RCEP in particular requires preventing anti-competitive practices in e-commerce sectors. Let's move on to the next slide. Well, arguably, there are still some problems in China's competition enforcement against the digital platforms before 2020. As I said, 2020 is a watershed year in China. For example, China's competition enforcement doctrine is rather outdated and cannot address competition problems when platforms achieve substantial market power. That's what we call accommodative and prudential principle. Influenced by the United States Chicago School, China's competition agency often assess economic efficiency in specific antitrust cases. Well, however, some abusive practices conducted by digital platforms cannot be assessed under Chicago School, especially the economic efficiency criteria. For example, when platform conducts 1 out of 2 practices or abuse consumer data, these practices may not harm economic efficiency, but do harm consumers' other important interests. Next slide, please. And lastly, I would like to briefly explain some implications of the RCEP may have on China's anti-monopoly enforcement. Firstly, it is arguable that China's government will adopt a more effective anti-monopoly doctrine, especially considering the RCEP's economic integration goal and competition policy plays a rather crucial role in forming a single and a common market, no matter in the Asia-Pacific region or in China. Additionally, China will take action to address some abusive practices conducted by e-commerce platforms. For example, when determining the market dominant position, China might improve the traditional Chicago School and look at the gatekeeper criteria. Even though 1 out of 2 may not harm economic efficiency, China's competition agency may take online consumer protection into account and identify the 1 out of 2 as the abuse of market dominance. Sophia, could you go on with the slides? Okay. When platforms begin to abuse big data, China may consider personal information in competition cases, well, just as European counterparts has done against Facebook. After the signing of the RCEP, China has witnessed a range of developments. China took antitrust investigations against the dominant e-commerce platform, such as Alibaba, and published the anti-monopoly guidelines on platform economy. It is thus expected that China will do more to meet the RCEP requirements when dealing with digital competition cases in the future. And that's all my, next slide, please. That's all my presentation today. I'm turning the audience to the moderator, Professor Cui.
Okay, thank you, Dr. Wu, for your presentation on the antitrust regulation of the e-commerce platform in China. Now we start our Q&A session. We have received quite a lot of questions from the audience. Let's start with Dr. Wang Lu's question first. The first question is from audience. The audience say, I'm interested in force majeure clauses in investment contract. Could you please elaborate further in that regard? I also have a relevant question, right? My question is the standard for what's the major or important difference between the standard of force majeure for states in the contract and that for a private party in a contract? Could you further elaborate a little bit for us? Okay, thank you.
You want me to address the question now?
Yes.
Or you like all the questions together? Yes, sure. Thanks very much.
Okay, I read all the questions for you. That probably it's easier. We can save more time. The second one is, what's your view on the ISDS words of invoking ARSIWA, and what's the implication for the investment treaty regime? The third one, thank you, Dr. Wang. This is a great and a crucial topic. Could you please further analyze how force majeure issues and COVID-19 will affect the future of investment treaties, particularly the bilateral investment treaties and FTA concluded by China? Okay, that's a first set of questions for Dr. Wan Lu, and then the question for Professor Zhou. The first one is my question. As a leader of the technology innovation, the US could easily raise national security as an excuse to sanction Chinese companies and ban export of key technologies. It's pretty hard for China to fight back, right? So in your opinion, are there any other market forces that limit the US choices? That's the first question, and I also have several ones. Let's check.
Okay, thank you very much, Professor Cui, for your question and also for the great questions from the audience. And I think all these questions are quite challenging. And I think, as I mentioned in my presentation and also noted in the paper, force majeure has been invoked in contract-based disputes, and actually the investment contracts often include force majeure clauses to allocate risk resulting from exceptional events. And in the arbitral practice, those I think compared to the treaty-based arbitration, in the contract claims, those foreign investors and host states have invoked force majeure to relieve themselves from the contractual obligations, particularly in cases of significant changes in financial, political, or social circumstances, such as the war or economic crisis. And the ongoing pandemic and Russia-Ukraine war, of course, have attracted more attention to the investment, to the force majeure clauses under investment contracts from legal and other circles. And I think it remains to be seen whether force majeure will be applicable in the current situation, as it's and the determination is a fact-based endeavor. But I think to prevent and manage potential disputes for the investment contract parties, special attention should be paid to the definition of force majeure contained in the investment contract, and also the applicable law to the investment contract, as shown in the ISDS jurisprudence. And given the considerable number of ISDS cases based on investment contract and the advantages of the resolving investment disputes through contracts, I think the force majeure clauses on the investment contract deserve more attention in the years to come. And in terms of the ISDS word invoking the LC articles on state responsibility, and also the questions in relation to the implication for the investment treaty regime, I think that's an interesting question. And actually, since the adoption of the RCEPA in 2001, we see an increase in ISDS cases interpreting and applying RCEPA with the development of the international investment law and dispute settlements. And although force majeure has been less frequently invoked in investment arbitration practice, other rules under the RCEPA, such as attribution and necessity, have been addressed by ISDS tribunals, and they are contesting issues. But as we can see from some scholars, they question the quantity of the RCEPA decisions by ISDS tribunals. And as mentioned in our paper, the treaty-based ISDS tribunals have referred to the RCEVA Article 23 in assessing first mover, but not engaged in more detailed analysis in that regard. So, but having said that, I agree with some commentators that the application of RCEVA provisions in SDS prevents use for case study on the development of SDS jurisprudence on first mover in general, and also illustrate the trends and features that have materialized in the past. And we think, I think we should also remember that SDS is still a new discipline, and RCEVA provisions was not created for SDS and investment law. So there is space for future SDS decisions to address the concerns. And on the other hand, I think some commentators actually said the increase of SDS cases interpreting and applying RCEVA reflect the fact that most investment treaties do not contain detailed rules on topics such as the consensus precluding wrongfulness, as I mentioned in my slides as well, in relation to the rules on first mover. So it's not surprising that RCEVA become a logical source of guidance on these topics. I think that may provide implications for the reform of investment treaty regime. For example, the states might think about to provide explicit provisions on exceptions, which would be considered as a primary rule and will prevail over customary contesting customary rules under the investment under the customary international law. So we'll see the new generation treaties impact on the rules of necessity and first mover and other contesting issues in the SDS in the future. I hope I addressed the questions. Thank you very much.
Okay, thank you, Dr. Wang. Due to time constraint, now we move to the second set of questions. Another three questions for Professor Zhou is first one is what are the major issues within the current WTO law or the case law on security exceptions? Second question is what reforms the WTO would need to make to address the ongoing challenge posed by growing abuse of national security by WTO members? Third one, trade secrets is an increasingly important issue. Many thanks, Associate Professor Zhou. You mentioned the Belt and the Road. I wonder whether you could elaborate your view on the future of the BRI and how it may affect the issue of trade and securities. Okay, now please, Professor Zhou.
Thanks, Guobin, and thanks for the questions. I will start with your question, Guobin, and then I will see how I go. As time is quite limited, so I may not be able to address all of the questions, but I will try my best. So the first question, Guobin, your question about it's quite a kind of recent developments in the U.S. trade policy and national security policy, which imposes another wave of export restrictions on critical technologies to China and other critical exports. That has happened before during the trade war between the two countries, and now we have seen another wave. Now, your question is actually very interesting because he asks, are there any market forces that could actually limit the U.S. choice? I'm not sure. When you talk market forces, I'm thinking about, the market operates without any government intervention. So what will be the demands and supply across the border between US and China? Two-way, not really just about US supplying technologies or other products to services to China, but also China supplies different kinds of goods and services to the US. So what will be the leverage that China has in terms of this the trade relationship with the US? I don't really have a clear answer at the moment. I think it's really recent developments But according to the experience we had during the China-US trade war, since 2018, we have seen that China has retaliated, but China's retaliation had very limited effects in terms of pushing US change policy, pushing US to reduce tariffs. So I don't think that China would have sufficient leverage in terms of using retaliation to push US change policy. I think the US politics at the moment is quite established in a way that they would treat China as a threat, security threats, and also a competitor. Now, I just want to give you a context about most recent developments in the US national security strategy, just released several days ago. The kind of the summary that caught my eye was really that the strategy paper said, in a context for the future of our world, the US administration is clear-eyed about the scope and seriousness of this challenge about China. It says China harbors the intention and increasingly the capacity to reshape the international order in favor of one that tilts the global playing field to its benefit, even as the United States remains committed to managing the competition between the two countries responsibly. So I think that what that means is really just the US trade competition, economic competition, technology competition, security competition, competition at all levels, in all aspects, would be considered by the US governments seriously, and how they should deal with China in those different contexts. So I think technology competition is obviously one of the most important elements in that competition, and how the US will treat China differently in future events and activities. So so if you ask me what China's response, I don't think fighting back is really a good option. And I mean, there might be a need for China to fight back, but to kind of demonstrate China's position, but it's really hard for China to fight back effectively. So what I'm thinking is, I think first of all, this is a new area and this is kind of a new development. I think the Chinese government needs to assess the impact accurately, the scale of the impact of the export restraints. And also, I think to focusing on what would be China's over-reliance on US exports of technologies. And also to look into what would be the commercial activities that would still be going on between the two countries in terms of technology imports and exports. Would China have alternative sources to obtain the technologies from other countries? China should continue to develop its own research and development investments, and should also be committed to its industry policy. I mean, it's really hard for a trade lawyer to say that, but I think that's the reality, because we have seen the competition on industry policies as well. And apart from that, I think WTO remains a very important forum for them to engage. And that's the forum that you would have a different sets of political interests there, and that would provide good opportunity for countries to reach a compromise on security issues. Diplomatic channels between the two countries at the bilateral level, I'm not sure what can be done, to be honest, because they have tried with the new administration, not really new now, but was not really successful and effective. So I think China should just do what it needs to do to develop its own technology. So it's really continued policy or priority in China. I think that's a correct direction to go. And there has been lots of finger pointing from US and other countries, but I think the US is doing exactly the same thing at the moment. So why China can't do that? So that would be my kind of partial response. We just have to observe what's happening. The question about major issues about the WTO laws, I think it's, first of all, I think it's a political issue, and we need to think about legal issues in the context of a political issue. And I think the critical question here is really how to strike a balance. In the two WTO disputes on security exceptions that I mentioned, the panels did try to develop a balanced approach, but their decisions provided only limited guidance. I think at least two issues have been left unaddressed or insufficiently addressed. The first is to what extent the limited scope of national security or security interests under Article 21 of the GATT provides room for the consideration of expanding economic security interests. So that's the first question. The second is where a measure has a mix of security and economic or trade-related objectives, how can we make sure that we deal with the protectionist interests and leave the genuinely security interests alone? So those are the two issues I think needs to be addressed. And also, I think broadly, given the ongoing trend of expanding scope of security interests and the expansive use of security-based policies, it is only a matter of time, in my view, that it would become extremely difficult, if not impossible, for WTO tribunals to adjudicate security-related disputes. The systemic challenge is the law, as it stands at the moment, provides only limited scope, whereas many matters which governments regard as national security nowadays fall outside of the scope. So I don't think judicial interpretation would be able to deliver a proper balance, and reforms of the WTO rules will be needed. So that really leaves me with the kind of final question I want to address before I stop there. Sorry for the question. The third question, I can't really have time to provide an answer on the Belt and Roads. But the second question on the reforms of the WTO, I think the reform is definitely needed because the current version of the security exceptions was drafted back in 1940s. So it does not really provide scope to accommodate the currently expanding security interests of governments. Ideally, governments should engage in negotiations to decide how they want to address security-related concerns and the nexus between security and trade. This, however, requires political will from all governments involved and their genuineness in engaging with each other and in producing a compromise. I mean, in my view, just very, very preliminary thoughts, I think there are several important elements in such negotiations. First, deliberation among major governments about the main challenges and possible solutions. Second, update the rulebook to improve the balance needed. Now, if that takes time, I think at least governments need to agree on a venue and a procedure for them to engage in consultation and reach a mutually agreed solution. And this can be a process separate from litigation. And finally, before any agreed solution or procedure can be reached, I think WTO members can consider whether they can use authoritative interpretation under Article 92 of the WTO agreement to address interpretative issues that can't be actually satisfactorily resolved by WTO judges. Now, having said that, without any political will, we will likely see more unilateral and confrontational actions, which will further damage the integrity and credibility of the world trading system, and making international trade less secure and less predictable. And we may see more tit-for-tat abuse of security measures, which is really not good for everyone. I'll just stop there. Handing over to you.
Thank you, Dr. Professor Zhou Weihuan. I think very interesting answers, and it sounds to me that things are a little bit pessimistic, right? If a superpower like the United States is facing a trade deficit, probably impossible to hold it accountable, right, for the WTO rules or to abide by a preset definition of national security. Okay, thank you. If we have time, we can discuss later. Now we move to the Professor Wu's questions. I have 4 questions. The first one is, since China has decided to continue the open up policy to the world, what China could do to improve its current competition policy? That's the first one. Second one, it is observed that big data has become the vital asset of big tech and the platforms. using anti-monopoly law is a good tool to regulate the use of big data. Third one, it is arguable that online competition is quite different from offline competition. What China can do to improve its digital economy by competition law. The first one, thank you so much for the talk, Dr. As China is piloting its e-CNY, the e-currency, will the e-currency be used in trade such as under RCEP? Is there any implication for competition? Okay, thank you. That's the question for you, Dr.
Thank you, Professor Cui, and also thanks for these questions. Since time is very limited, and I will put forward my quick answer very quickly. Firstly, about the China's opening up policy, I think China has taken the reform and open up policy for more than 40 years, and will continue to do so in the long future, since the CPC National Congress has argued that it will continue to open up and embarrass the world. Therefore, China will definitely, from my point of view, follow some international rules, especially some international or treaties with China as member states. When following these international criteria, these rules or provisions will have substantial impact on China's domestic policy, including competition policy. It is arguable that some very important regional treaties that China valued, such as the RCEP, the CPTPP, will have more implications on China's competition policy and shape China's economic future. And about the second question, I think in modern commercial practices that big data has become very important asset for big tech and digital platforms. In my view, that the use of big data should be regulated by many laws, such as contract, tort, intellectual property, administrative law, and also competition law. Competition law pays attention to the competitive process and how big tech platforms use big data. About the third question, I think online competition is quite different from the offline competition because online competition has some features such as network effects or winner takes all features. I think China has decided to build a digital China. It means China will rely on digital economy as one of the main economic driving forces in the future. On the one hand, I think China needs to encourage the development of digital platforms. And at the same time, China should guarantee that practices conducted by these platforms, particularly conducted by those platforms with a dominant market position, should not harm competitive process and consumers' interest. Therefore, China should further improve the competition enforcement by establishing clear criteria for online platforms so that big tech companies can achieve legal certainty. And I think the recent anti-monopoly guideline on platform economy is just the start, and the Chinese competition agency and the government should do more to make the some criteria very clear. And about the fourth question, firstly, I should admit that I'm not an expert in e-currency issue, but I want to try to answer these questions. I think yes, China is now encouraging the e-currency, namely the RMB, to replace some traditional RMB. And I think it will make some implications on international trade. But I think one of the most important issues is that whether other countries will recognize the e-currency proposed by China. As we all know that the US dollar still has the dominant position in the international from the international level, whether China's e-currency, the e-RMB, can be recognized by other countries, especially in the from the regional level, as China is a member state of the RCEP. Whether the e-currency will be recognized by other member states, such as Australia or the Asian countries, is still a question. And I know that CIVO is now doing research on the e-currency. And I think the first step is that other countries should recognize the e-currency proposed by China, and that's follows the question whether there will be any implications for competition. And from my point of view, that even though we look at the domestic situations in China, that consumers are still used to pay goods by some other kinds of ways, such as Alipay, WeChat Pay, or Apple Pay. So it's still a long way that we promote the e-currency and see the implications. That's all my answers, Professor Cui.
Okay, thank you, Dr. Wu. First, I have another question about the goal or purpose of antitrust enforcement in China. In your lecture, you mentioned that China may not only consider the purpose of protecting competition, but also the purpose of consumer protection. This kind of two types of purpose may, in most of the time, they are parallel, right? But in sometimes they are in conflict. Do you have anything about the possible conflict between these kind of two goals if we allow the antitrust agency to consider this kind of purpose? Okay, thank you.
Thank you, Professor Cui. I think that's a very good question about antitrust harm, and it's very fundamental question that China should answer, because from the comparative law view, the United States still holds the Chicago School, which believes that economic efficiency is a very important view that antitrust law should promote. And if we look at the other side of the Atlantic, the European counterparts may have some other opinion, especially considering that recently some European competition agencies consider some other factors except to economic efficiency, such as the GDPR protection, into consideration to in their competition cases. Well, from my point of view, there may be some conflicts, but the most important question is whether we see the criteria of competition, whether competition is equal to the economic efficiency or consumer welfare, or whether it can incorporate some other factors such as the personal information or online protection. In my view, that in digital competition, there are some differences with competition offline, such as traditionally offline competition is based on price theory. That means that companies compete with their lower prices and more outputs. But in the digital competition, sometimes we saw that the platforms compete. They do not rely on price, but with other factors such as network effects or winner takes all. That means if we see that they do not compete with price, then we cannot assess the antitrust harm with price. So in some, I think in some circumstances, we should consider other factors such as the data protection, personal information protection, and other consumer protection. If they use these factors to compete, we should consider these factors when we assess these antitrust cases. That's my briefly answer, Professor Cui.
Okay, thank you, Dr. Wu. We still have 3 or 4 minutes. So I read the comment, Professor Zhou, on the chatting board. So you means we need a U-turn from the current confrontational and unilateral approach. Could you further elaborate on that a little bit? Thank you.
Thanks, Professor Cui. What I mean is really, I think at the moment, as you said, sounds a little bit kind of pessimistic about the international environment. The environment at the moment is starting from the U.S.-China trade war, and perhaps a little bit earlier than that. And there has been rising use of unilateral measures against each other, and we're seeing a shift from a cooperative approach as established as a kind of habit of cooperation in the past, but then becomes everyone tries to protect its own interests using unilateral measures, and when there is a need to confront, they do that. So I think if you look at the U.S. tariffs and the Chinese tariffs and all other kinds of recent tensions at bilateral level, and sometimes involves multiple parties, we're really saying not only based on national security, but all sorts of other industry policies, including subsidies the U.S. recently introduced. No one is really coming to think about what the international rule on subsidies, what are the international constraints on unilateral actions, and what would be the kind of the traditional hope for countries to collaborate with each other to sort out these problems. But they have moved away from it. I mean, I would say the U.S. was leading the move from the multilateral cooperation. So I think that's a wrong approach. And as you can imagine, that if every major economy basically taking the law into their own hands, we will have a lawless order, international order, and everyone can do whatever they want. And if you look at the recent developments in the EU's anti-coercion instruments, right? So those is another recent developments of unilateral measures, and it basically allows the EU to take retaliatory actions when they think that there is a coercive action taken by a different country. So I mean, China was obviously a target, but it also involves other kinds of coercive actions taken by all other major economies against the EU and EU states. So that's just one of the recent examples. I would think, I mean, China has been doing the same thing, right? Anti-foreign sanction law, and those kind of includes all sorts of security interests and other economic interests at the same time to allow China and also ask Chinese companies to take action in response to foreign sanction or any foreign actions that might be seen as a damage to Chinese national security. So again, I think surrounding the security interests, we have seen a clear trend that so many countries tries to expand unlimitedly the scope of security interests. If you think about what we traditionally call security, national security, and now the security interests have expanded into all areas. Climate action is a security issue. Supply chain is a security issue. China also sets out, I think, clearly in the national security law in 2015 that any attempts to stop or cause a impact on China's industry policies and economic developments can be seen as an economic security issue. So there is boundless security interests in every country. And then once these measures, foreign measures, are seen to be a security threats, and then that will justify the use of measures, trade measures being part of it, but also investment measures and other sorts of financial sanctions to deal with these actions. So where that would end, right? And thinking about what would be the counterfactual with the cooperation, with governments coming together to sort out these issues and agree to constrain their unilateral use of security or abuse of security measures, I think would be the way to go. I'm still, I think, optimistic in terms of international cooperation, and that's always what I would call for. But at the moment, I think the political will hasn't come to the stage that will provide a solid platform for governments to collaborate.
Yeah, interesting. I think probably in the future, the major powers needed to achieve that kind of trade balance, right? Otherwise, they always could resort to this kind of excuse to impose some kind of restriction or sanction, where maybe in the future, the former US President Donald Trump's reciprocal approach maybe is the answer. I don't know. Okay, thank you. On behalf of the organizer, I would like to thank the three speakers, Dr. Wan Lu, Professor Zhou Weihuan, and Dr. Wu, for your wonderful presentation and answers. And I also thank to the audience for your provocative, interesting questions. And okay, let's stop here. I give the podium to Professor Wang Heng. Okay, thank you.